Car crash cases, defective products, dangerous drugs, injuries, and abuse. Across the state of Alabama, the attorneys, proudly sponsored by the law firm of Hollis Wright, are here to serve you. Your tough legal questions answered by our experts. The attorneys with Josh Wright from the law firm of Hollis Wright and host David Lamb.
Good evening and welcome into the attorneys. Thank you so much for joining us on this Sunday evening. Hey, for the next half hour, we're going to be talking about a subject matter that all of us try to avoid, but unless you want to go to jail, you better not. We'll tell you more about that coming up. But hey, love to have you join the show. Ways to communicate with us right there at the bottom of the screen. Also, don't forget, attorneys from Hollis Wright standing by live to speak with you all throughout the show, so take advantage of that. Josh Wright, managing partner of the firm.
Good to see you, my friend.
Good to see you.
How are you?
I'm good.
Good.
They say there are two things you just can't avoid, right?
Well, one of them happens to be taxes.
That's right, and that's our subject matter, isn't it?
So Brad Howell, who's been on the show many times over the years, first of all, this is a brand new show that we've never done on the issue of taxes because the laws have all changed since our last time that we did the show, and it's a super important show. We're going to talk about things from what happens if you don't pay your taxes to what are the tax bracket changes. And there's so many differences that have come into place in the last year to 18 months from the 2017 legislation. Brad's going to be able to update us on that. So I think that's super important. So Brad, first of all, welcome to the show. Glad to have you on.
Always good to be here.
You work with Meadows and Howell here in town.
Mm-hmm.
And is this kind of your sweet spot, taxes? This type of issue, because I know you're busy during this time of the year.
Oh yeah. So we get a lot of questions this time of year, obviously with it being tax season. And even throughout the rest of the year, this is the bulk of our practice. We also do a little bit of business law because it kind of ties into taxes. So we do a lot of business entity creation. We help individuals determine which business entity is best for them, especially from a tax perspective. But primarily it is tax debt resolution.
All right, so let me ask this question, a question that you weren't expecting. How big is the new tax code with the changes? It's got to be huge.
I don't know how big it is. What I can tell you, though, is there are a lot of there's a lot of ambiguous language in there now that they're going to have to try to go back and explain. So a lot of the tax code that we see that goes up to 70,000 pages, a lot of that is regulations, treatise information that kind of helps explain it. So we're going to see that increase probably exponentially with all these new ambiguities that they're going to have to clear up.
All right, so someone calls you and says, look, I've heard there's a new tax code, it could impact folks. How do you explain that process to them? Because there are some obviously significant changes as to tax brackets, some of the deductions and those types of things. How do you just kind of overall explain to folks some of the changes and the impact that it'll have?
Sure. For the new tax laws, we kind of have to look at, what is their concern? Is it on the individual side or is it the business side? Because those are obviously, the changes are completely different. Just for one example, if you're a corporation, the top tax bracket used to be 35%. It's a drastic reduction now to 21%. Whereas if you're looking at the individual tax brackets, there's not a whole lot of change. There's still 7 individual tax brackets. The 10% and 35% have remained the same. The top tax bracket of 39.6 has dropped down to 37%. And then anywhere in between, you've got changes of 1% to 4% basically that have been decreased. So it kind of depends on an individual's particular circumstances and what they're looking at, because like you've mentioned, there's a variety of changes that we really have to look into.
It's a different time now, there's no doubt.
It certainly is. One of the things whenever there are any sort of tax law changes, a whole lot of rumor and speculation. A question here, and we love getting questions from you all, so please continue to send them in. I've been told that I won't be able to itemize deductions. Is that true?
It's not true. You can still itemize deductions, but the big issue is that the the standard deduction amount has actually increased. So previously it was $6,350 per individual, and I think in 2018 it was going to increase prior to this tax change to $6,500. That has now increased to $12,000 per person, and so for joint filers it's now $24,000. What that means is that you have a greater standard deduction. So if you're going to itemize and what you're itemizing is not going to be greater than the standard deduction, there's no point in itemizing. So for the vast majority of taxpayers who may have itemized before and claimed $10,000 in itemizations because of the fact that it's greater than the previous $6,350 standard deduction, they no longer need to itemize because they've got a $12,000 standard deduction.
So I know a question we always get is exactly how do deductions work? I mean, at the end of the day, increasing the standard deduction by almost $6,000 reduces the tax amount somebody pays, is it not?
It does. One other thing to look at, though, is they've also gotten rid of the personal exemption amount. Okay. So you had the standard deduction amount, but then you also get to claim $4,050, I believe, in 2017 per individual. So that would include yourself, your spouse, any dependents you claim. That's been done away with completely. So, and realistically, an individual may have been able, if they didn't itemize, to previously claim $10,000 in the standard deduction and personal exemption. Now they just have the standard deduction of $12,000. And really, for some people that itemized, it may be detrimental to them because, for example, if they were itemizing $10,000 in expenses and had a personal exemption of $4,050, they would have been able to claim $14,050, whereas now with this new standard deduction, it's just $12,000.
So let me ask you this. Is it a good idea with the new tax changes, do you think, to go to a tax preparer, especially in these coming years now that things have changed?
Definitely. We may potentially see some new changes in the law, but you can go ahead and meet with a tax preparer now. A lot of preparers, if you've already had one work on your returns, they may even send you with your 2017 return an example of how those numbers might change next year. So it's always worthwhile to go see a tax accountant or someone who's certified to prepare returns. That way you can get a little bit more detailed information that helps you out in your specific situation.
So what areas of the changes that happened in 2017 are you expecting that could be adjusted by the legislature down the road because of maybe ambiguities or mistakes that have been made?
Sure. There are a couple of things that they've highlighted, one of which is for pass-through entities. So we're talking about LLCs and S corporations, partnerships, things of that nature. For self-employed individuals, they have a 20% deduction that's taken on their individual return, that's taken off of their net profit. That is coming into question as to whether or not that's going to apply to all pass-through entities. Specifically, one issue that I've seen raised is that for farmers cooperatives, they're actually now getting a benefit that other businesses that are not a cooperative but operate similarly to the cooperatives, they're not getting that benefit because farmers now are getting a 20% deduction from the sales that they make to a cooperative. And so now that's going to be unfair to a lot of other businesses that are not cooperatives, and they're going to have to either shut down or reform. So there are a lot of different businesses and industries that are coming forward and pointing out these unfair regulations or regulations that are unclear and ambiguous, and they're asking them to be changed.
Are companies coming now and adjusting their structure in order to take advantage of some of the benefits of the tax laws? For example, some of the pass-through entities have bigger deductions than an LLC or a corporation may. Have you ever seen some of that?
I would imagine that that's something, we haven't seen it yet, but I would imagine that's something that once the word gets out about some of these changes that people are going to want to do. And especially even if they don't change their actual entity, the way that they're structured. For example, for an S corporation, you have W-2 wages that you can pay yourself as an owner, as well as net profit that flows through. You may want to pay yourself less in wages and more in the net profit that flows through because of that 20% deduction that you're now getting. So there are definitely some changes that can be made that someone's going to have to definitely look at, especially tax preparers and tax attorneys, in detail to see what's beneficial.
This is complicated stuff.
It is.
I mean, it's why you want to go to a tax preparer for sure, a guy like Brad that can walk you through it.
Yeah, Brad seems to know his stuff. We're getting a lot of questions about the changes and how that affects deductions. Whenever we come back, let's talk about student loan interest. Can that be deducted? And also a question about mortgage interest as well. But let's step aside.
I also want to talk about what can't be deducted now, because there have been some changes in that way too.
All right, so we're stepping aside. Time for us to take our first break. A good opportunity to remind you that Hollis Wright, active on social media. If you are not following the firm on Facebook, Twitter, also Instagram, then you need to get on it. Some really educational, informational uses of those social media platforms. Take advantage of that. Stay tuned. We've got more of the attorneys coming right up.
I'm Josh Wright with the law firm of Hollis Wright, a personal injury law firm. Thank you for watching The Attorneys. Now, we hope you, a friend, or a loved one never needs legal counsel for a case. But if you do, the goal of the show is simple. Provide answers and legal counsel when you need it the most. Your call to the show is free, so if you have questions specific to the show or related to other accident or injury-related topics, you can call, email, or text us. Or you can also follow us on Facebook or Twitter, or simply contact us by going to hollis-wright.com and click on the Contact Us link. We know your time is valuable, so thank you for spending it with us watching The Attorneys.
Welcome back into The Attorneys, all about taxes tonight, and would love to have you join our conversation. At the bottom of your screen there, you see ways you can join this conversation. Also, don't forget, attorneys from Hollis Wright standing by all throughout the program tonight. That phone number that you see there on the screen, just call that, and the opportunity to speak with an attorney standing by live right now. Now, what is taxing on the voice is whenever you coach your son's baseball and basketball teams.
Yeah.
So your Barry White,
yeah,
your Barry White sound. That's
I like the down deep sound. Maybe next week my voice will be back. I'll stop yelling a little bit on the.
I want to make sure they know you're not hollering at us. It's motivating those kids.
Definitely not. Just motivating the kids. You know, and one of the nice things that I'm excited that we do offer is the calls, texts, emails. You know, if there are legal related issues that they have related to this show, or related to other issues that they're facing, you know, people should feel comfortable and not intimidated to contact a lawyer. And this is a great format for them to be able to do that. So I hope they'll take advantage of it if they got a legal related issue.
Me too.
And hopefully we'll get our voice back in the process.
It'll work.
All right, hey, so let's talk about this, because I do think this is important. And you and I mentioned this kind of in the pre-production of this show. Some of the things that have changed, but specifically, what are some deductions people used to be able to take that no longer are they able to take?
Sure. So there are a lot of itemized deductions on the individual returns on the Schedule A of the 1040 that you no longer are able to take. There are a variety of them. Some of them include casualty losses or theft losses. One exception to that is that if it is a federally declared disaster area, then you will be able to claim it. So that kind of rules out, for the most part, theft losses, because I've never seen a theft loss be declared as any sort of casualty. Maybe if there was some sort of rioting, it might be. But then you've got other things like unreimbursed employee expenses, and that's a big thing that we saw a lot of people talking about in relation to school teachers who have to provide papers and pens and various other supplies for the classrooms. There are also some limitations based upon your reimbursed employee expenses, so anything that's for parking and transportation you cannot claim. And so those are just a few of them that we're looking at. And for some people, they are a pretty big changes that they're no longer able to deduct. You can still deduct your mortgage interest. You can still deduct a lot of moving expenses. So there and job search expenses. So there are things that have remained, but a lot of things that have changed. So if you've been relying on those itemized deductions, make sure you review and see what's going on.
So I know you've gotten this question before. I mean, what's the netted out for us? What is the new tax code from 2017 more advantageous for businesses, but maybe the same as it was for individuals? Is it more advantageous for individuals and not as good for businesses? Is it better for both? How do you net that out? Kind of explain that.
Yeah, it really depends, again, on a variety of factors. So as we kind of discussed during one of the breaks, the 20% deduction for pass-through entities, there is a limitation on that for professionals. So you have doctors, attorneys, and consultants, and there is some debate going on as to what actually classifies as a professional as well. So that's one thing that, yes, if you're a pass-through entity, that may be beneficial to you unless you're a professional and you earn a certain amount. As far as the individual income tax brackets, again, it kind of depends. For joint filers who, I believe it was before in the 33% tax bracket, you would earn between $230,000 to $400,000. That is roughly the same now in the 32% tax bracket, whereas if you're an individual filer, there's a drastic difference. Previously, you would be in the 33% tax bracket for anywhere from around $190,000 to $400,000, whereas now with that 32% tax bracket, that's basically the equivalent, it's only $150,000 to $200,000. So you take someone who was earning $250,000 last year and will earn that this year, They were previously in the 33% tax bracket. Now they're going to be bumped up to the 35%.
Gotcha.
So really, it's all depending on your individual circumstances as to whether it's beneficial to you or detrimental to you.
Another reason why you want to go to a tax preparer or a guy like Brad to be able to answer these questions, because there are probably some things that you can do to make it more advantageous for yourself.
This conversation does kind of make my head swim.
Yeah.
I mean, man, you need.
I get it.
Yeah, it's easy to get confused.
Go ahead.
I don't know if you guys covered this one or not, but another question we've got that does affect a lot of folks. What about deducting student loan interest?
Mm-hmm. Yeah, there's been some confusion about that because obviously this is something that the media covered very closely, and we were initially getting reports that student loan interest in the first draft of the bill was going to be just completely removed. Mm-hmm. That's something that when the bill finally passed, they allowed back in, and so nothing has really changed with that. You still have up to a $2,500 amount that you can deduct in student loan interest, and that does start to decrease and eventually phase out depending on your income. One of the interesting things, though, in relation to education expenses that has changed is for 529 plans. And those are plans that you can place money into for a dependent, or, your child's future college expenses or higher education expenses. That is still in place and is still tax deductible, but they've expanded that so that you can use those expenses for primary education. So if you have private tuition that you're paying, if you're paying tutoring costs for your child, those are things that you can now pull out of that 529 and still put into the 529 as a tax deferred plan.
One of the issues that always comes up in these shows is audits and criminal penalties. Let's talk about that just for a second. From an audit perspective, how common is it for an individual tax filer to be audited?
Sure. If you're just looking at the overall statistics, it's less, I think, than 1%. And that's fluctuated some. I think the last tax year that the IRS has statistics on, or the most recent, is 2016, and that has dropped, I believe, to 0.7% chance for an individual tax return being audited. There are obviously things you can do that can increase your chances of being audited. If you're repeatedly claiming a loss every year, especially if you're operating a business, the IRS doesn't believe that people are going to stay in the same business for 5 to 10 years operating at a loss every year. So that can trigger an audit. There are certain types of industries that get abused. Nonprofits, real estate companies, there are a lot of different ways that people have abused those in order to cheat on their taxes. So that has opened up a higher chance of audit for individuals in those industries. So overall, not really common, but again, it depends on what you're claiming and what you're doing for a living.
How long should you keep your tax documents?
Forever.
Okay.
I mean, if you're looking for a more realistic answer, probably 6 years, because both the state and the IRS, they have 3 years from the date of a return being filed to audit you, or to enter an assessment rather. That can be expanded if they do an audit and they find that you underreported more than 25%, then that expands that statute of limitation to 6 years. Same thing for most criminal charges, there's a 6-year statute of limitations. So generally 6 years, but with today's technology and the fact that the revenue agencies do take copies of documents, you can digitally store those and reduce your clutter and keep it on file for virtually forever.
When we come back, I do want to talk about the criminal component to this whole process. If you put your head in the sand, for example, and you don't file a tax return for years, what happens to you? Can you be criminally prosecuted? Those are some things I think we need to talk about.
Good deal. We'll step aside right here. This is our final break of the evening. Just a few minutes remaining here of the show, and a few minutes remaining for you to get in touch with attorneys who are standing by from Hollis Wright right now. Give them a call. Join our conversation. Stay tuned. The final segment of The Attorneys coming right up.
I'm Josh Wright with the law firm of Hollis Wright. In court, attorneys are not allowed to tell juries certain things. For example, we cannot talk about a defendant's net worth, meaning the defendant's ability, resources, or insurance to pay a verdict. In this week's Legal 4-in-1, we're answering the question, why can't lawyers talk about a defendant's net worth to a jury? Now, Rule 403 of the Alabama Rules of Evidence states, in part, relevant evidence may be excluded if its probative value is substantially outweighed by the danger of unfair prejudice. Long-standing Alabama cases have held that the net worth of a defendant falls under this catch-all rule and is to be excluded. The reasoning behind the rule is that if a jury knows a defendant is wealthy, then the jury might award more money to the plaintiff. And this goes one step further. If an attorney makes any remarks that suggest the defendant is responsible because he is wealthy or rich and the plaintiff is poor, that can be grounds for a new trial. If you're ever on a jury, the reality in our state is this. In almost every lawsuit that goes to trial, the attorneys representing both the plaintiff and the defendant have already looked at whether there's sufficient insurance coverage or assets to satisfy a verdict. Most likely, the parties would not pursue a civil lawsuit if damages could not be paid after a jury returns a verdict. So even though lawyers cannot mention the net worth of a defendant during trial, there likely are resources available to pay a verdict in court. Please remember, your call, email, or text to the attorneys is free. All of us at Hollis Wright want to help answer your questions on real issues you face. And remember, a competent lawyer will respond to every question you send in. That's our pledge and promise to you. And as always, thanks for watching The Attorneys right here on WVTM 13.
Time flies when you talk taxes. Welcome back in to the attorneys. About 7-8 minutes remaining in the show. So if you have a question, go ahead and take advantage of that opportunity to let us know about it. That information at the bottom of your screen. And again, attorneys from Hollis Wright standing by for about 8 more minutes. So give them a call. Josh?
So Brad, when we left to break, we were talking a little bit about some of the penalties and issues that you can face if you underreport, how long you should keep your tax information and documents. Let's talk a little bit about the criminal side of this. How does that play out? I mean, can you be criminally prosecuted for failure to pay your taxes or for intentionally underreporting? And if so, can you face jail time, or how does that generally work?
Right, and it's a very good thing that you mentioned intentionally underreporting, because as with most criminal laws, that's effectively what they're looking at is intent. So if you merely did not file a return, even if you intended not to file it, the IRS or State Department of Revenue has to prove that intent. So the fact that there are not returns on file does not mean that there's initially going to, or that there's ultimately going to be criminal charges. Similarly, it doesn't really matter what you owe. It's all about the reason you owe and whether or not you had an intent to evade payment of taxes. So even if you owe $5,000, you could get criminal charges if they can prove that intent. Whereas if you owe $1 million, doesn't necessarily mean you're just going to have criminal charges slapped on you. That's a common question we get, but again, they have to prove intent. And so unless you give them information or documentation that shows that you had intent, then you should be good to go.
So you recommend, though, if there's a issue, should people come to counsel to get advice in preparation of kind of defending themselves?
I would definitely say so, because a lot of times there may be something that you need to appeal. Even if it's very innocuous, you just have a disagreement with the IRS as to what's owed and why. You may have, at some point in time, have to go to the United States Tax Court. So there are certainly certified accountants that, not many that I know that do tax debt resolution, but if they feel comfortable doing it, you can certainly retain them, or you go to a tax attorney knowing that they can take it to the court if need be. But definitely try to get someone involved, stay on top of things, because if you just bury your head in the sand, it's only going to get worse. Yeah,
so talk about the criminal penalties. It sounds like if you're found guilty of doing something intentional, can you go to jail? Do you pay back taxes? Do you pay interest? How does that work?
Sure. So if they find criminal intent, you're going to owe the back taxes in addition to possibly having to go to jail. The average sentence for, I think, the most recent batch in 2014 of criminal prosecutions that they went through was around 48 months, with the maximum being 27 years. So it could potentially be something it's obviously, it could be a felony if it's a federal issue. So it's something that you definitely don't want to try to intentionally evade taxes.
And then talk about liens, because I know there are lots of folks that have questions about outstanding tax liens, IRS liens. When we resolve cases, one of the things we look for is liens. And if someone has a lien, we've got to resolve those liens before we can distribute money to that individual. How does that process work, and how do you get a lien resolved?
Sure. So generally speaking, anytime a debt is going to be owed and a final assessment is entered, there's a statutory lien regardless. But a lot of times what ties up the transfer of property or being able to access assets is the public lien that's filed. The IRS will generally file a lien if it's $10,000 or more that's owed. The state will usually file it regardless of the amount owed, but I believe the threshold's around $2,500. You can resolve those by obviously paying the debt in full. If you owe $50,000 or less and you set up a payment plan that will pay it off within 72 months prior to the entry of the lien, you can avoid that. Or if you can get it down to $25,000 or less and the lien's already been filed and you pay that off within 60 months, they'll go ahead and withdraw the lien.
So that's not a process that you should handle on your own. You recommend definitely getting someone involved to assist you, whether it's a tax preparer, attorney, etc.
Certainly, because there are a variety of things that you can look at as to whether or not the assessment's correct, what's the best option for your payment plans, where you're at currently. So definitely have someone come in and take a look at it.
You know, a lot of people think if I am incapable of paying my taxes in a typical year because, you know, I didn't have enough withholdings, etc., that the IRS just throws you in jail. And the reality is, a lot of times they're going to work with you and they're going to try and work a payment plan out because their goal is the same goal that you have, which is to try and get that stuff paid.
We just have about 3 minutes left in the show, but I'm just curious, Brad, from you, having seen this a great deal, is what Josh is talking about there, kind of ignoring and hoping that it goes away, is that one of the most common mistakes you see folks make?
It really is. You know, some people are of the opinion if I don't open the mail, well, then they technically haven't served me, or you know, I'm not going to have the money to pay these taxes, so I'm just not going to file. You know, ultimately, if you have a W-2 or a 1099, the IRS is aware of your income. The State Department of Revenue is aware of your income. If you don't file a return, they're going to file one for you at some point, and it's probably going to be a higher amount that you normally would owe because they don't know what deductions you're eligible for, what credits you're going to claim, things of that nature. So if you bury your head in the sand, it's not going to avoid the problem, it's just going to exacerbate it.
Well, and not only that, but, you know, at the end of the day, if you bury your head in the sand and don't do anything about it, eventually it's going to have significant consequences on your ability to purchase a vehicle, your ability to maintain your home, because it could be foreclosed upon. There are a lot of things. At some point, the tax man does, in fact, come and kind of handles it for you. And so, you know, finding a way out by getting competent counsel, talking with a tax preparer, those are the most efficient ways to get this process done.
We're just about out of time. A couple of minutes remaining, but I want to give both of you the opportunity for a final thought. And Brad, if you would, you go first, please, sir.
Sure. So I guess my general final thought is to kind of what we've been talking about the last couple of minutes is just stay on top of things. There are penalties that are going to arise if you file the return late, so go ahead and file it even if you don't have the ability to pay. They're not going to immediately come in and collect. There's several notices they have to send out, and then like Josh had mentioned, you have the option of establishing those installment agreements and paying it off over time. So just make sure you know what the liability is, make sure you get the returns filed on time, and if you need help, go seek it.
Yeah, so there are so many changes in the law since 2017. We've only highlighted a very small portion of those today. There are a lot more changes out there that could impact the typical person that is filing, that's an individual, and those businesses out there. Get with a tax preparer to make sure that you're maximizing the benefit of the new tax code for your business, for your individual tax return, and also to be able to determine, should I file individually or should I file jointly? Get with a tax preparer, and hopefully people will be able to take advantage of some of the changes that happened in 2017.
Good stuff, gentlemen.
Good job, Brad.
Appreciate it.
Nice job.
Nicely done. Appreciate you guys being with us, and as always, we really appreciate you joining us each and every Sunday evening. As we wrap things up, the way that you can still get in touch with the firm of Hollis Wright, go ahead and do that if you need to do so, always there and available for you. As we wrap things up, thanks again for joining us. We appreciate it, and we'll look for you next time right here on The Attorneys.
Thanks for watching The Attorneys, sponsored by Hollis Wright.